Welcome, everyone. My name is Maria Zhu. I am an assistant professor of economics and a senior research associate in the Center for Policy Research in the Maxwell School of Citizenship and Public Affairs at Syracuse University. Before we begin, I'd like to acknowledge with respect the Onondaga Nation, firekeepers of the Haudenosaunee, the indigenous people on whose ancestral lands Syracuse University now stands. I'd also like to thank the staff in the Center for Policy Research who coordinate the logistic for our What's at Stake series, particularly Alyssa Kirk. And thank you to the Maxwell Dean's Office for their support of this event. Today's panel is part of the What's at Stake series, organized by the Center for Public Research in the Maxwell School. CPR is a research center that supports policy-relevant research and disseminates knowledge that enables leaders to make informed policy decisions and provide effective solutions to critical challenges in our local region, state, country, and across the world. What's at Stake is a series of timely discussion panels featuring multidisciplinary groups of Maxwell faculty who provide insights and answer questions about the implications of recent changes to laws and policies or new developments. Today's panelists will focus on the implications of the Supreme Court's decision this summer that made the use of race-conscious college admissions practices unconstitutional. Here to discuss the implications of this decision for colleges and students are four Maxwell faculty. They will each provide opening remarks about the court's decision from within their specific areas of expertise. We will then open it up for a discussion and Q&A. Audience members should enter your questions in the chat box, and we will try to get to as many as we can. And please make sure that in the chat box in the to line you have my name. My name is listed there, and I will moderate all the questions. And so before we get started, let me introduce our panelists. Professor Thomas Keck is the Michael O. Sawyer Chair of Constitutional Law and Politics and Professor of Political Science. Professor Keck's research focuses on constitutional courts and the use of legal strategies by political movements on the left and the right. Professor Ying Shi is an assistant professor in public administration and international affairs. Her research is in the area of labor economics and political economy with a focus on education policy. Professor Amy Lutz is an associate professor of sociology. Her research focuses on racial and ethnic and educational inequalities. Her most recent work has considered how different affirmative action contexts have affected college enrollment and completion among different racial and ethnic groups. Professor Sean Drake is an assistant professor of sociology. His research focuses on residential segregation and educational inequalities that disproportionately affect students of color. And I will be joining in on the conversation with the panelists today as well. My research is in the area of labor economics and the economics of education. And for the last several years, much of my work has focused on affirmative action and racial biases in schools. So let's go ahead and begin with some opening remarks from our panelists. Professor Keck, let's start with you. Could you give us a brief overview of the Supreme Court's decision and how it fits into the historical context of other decisions about affirmative action?
Great. Thanks, Maria. And thanks, everyone, for joining us today. So in June of this year, the Supreme Court reversed a number of longstanding precedents to hold that both public and private universities are barred from considering applicants' race during the admissions process. And I just want to get us started with two quick introductory points. One is about the lawyers who brought these challenges, and the other is about the judges who decided them. So the lawyers first. Conservative lawyers have been litigating against affirmative action for 50 years, roughly. There's now a pretty robust network of conservative public interest law firms, they're often called. So ideological or politically organized litigation firms that, like many organizations on the left, use legal strategies in an effort to push politics and policy in their preferred direction. So there's lots of these groups. There's a group called the Center for Individual Rights in Washington, D.C. There's a group called the Pacific Legal Foundation based in California. They've both litigated against affirmative action for decades. But the sort of leader of the movement at present is a guy named Ed Blum, who founded a group called Students for Fair Admissions. And Mr. Blum has been suing universities for about 15 years now, arguing that any consideration of race in the admissions process violates the 14th Amendment Equal Protection Clause for public universities, or violates federal civil rights laws for private universities. And he orchestrated the two cases that the court just decided in June. So one was from UNC Chapel Hill and one was from Harvard, and they were both orchestrated by Blum's group. Blum is now working on a series of follow-up lawsuits, right? They're not done. He's working on a series of follow-up lawsuits, some targeting universities and some targeting prestigious public high schools, arguing, among other things, that even race-neutral admissions policies are prohibited if they're designed to achieve a racially diverse student body, right? So that's something I'm sure we can talk a little bit more about. So the litigation effort is ongoing. Okay, so that's where the cases are coming from and who's bringing them. Now, a quick word about the judges. So I can't see everybody in the audience here. I don't know if anybody joined us this time last year. We held one of these panels focused on the court's decision reversing Roe versus Wade in 2022. And the affirmative action story on the court mirrors the abortion story in several key ways, right? On both issues, the current court has reversed 50 years of precedent. On both issues, the court's liberal decisions from the 1970s, so protecting abortion rights in Roe versus Wade, protecting affirmative action in cases from the same era, those decisions had come under sustained conservative critique, right, for years and years. On both issues, there was an earlier period where it seemed like the court might abandon those precedents, right? So back in the 90s and early 2000s, Supreme Court that at the time consisted mostly of Reagan and Bush appointees seemed on the verge of putting an end to constitutional abortion rights and to affirmative action, but it ultimately backed off. In both instances, it scaled those policies back. It scaled back abortion access. It scaled back the permissibility of affirmative action in the early 2000s, but it decided not to get rid of them altogether. But then President Trump added 3 justices to the court, and its emboldened conservative majority decided to go for broke. So one last parallel between these two sets of cases, so again, abortion and affirmative action, is that in both of them, the conservative justices who make up the majority on the contemporary Supreme Court purported to focus on the original meaning of the 14th Amendment, right, which is a longstanding set of arguments made by conservative and lawyers and judges saying that when we're interpreting the Constitution, our goal should be to interpret it as it was originally understood. So abortion rights are not constitutionally protected, they argued, because when the authors of the 14th Amendment wrote the word liberty, no one at the time thought that they meant reproductive rights. And affirmative action is not constitutionally permitted because when those same authors wrote the words equal protection, people at the time did think that that meant that the government could no longer treat persons differently on the basis of race. Now, I'm at time, but I'm going to just say one last sentence about this. In purely historical terms, one of those arguments is way stronger than the other. Right? It is clearly true that the original meaning did not include reproductive rights. The original meaning of the 14th Amendment did not include reproductive rights. Whether that's something that should bind us forever is a good question, but it's clearly true as a historical matter. It is not clearly true. In fact, I would say that it is clearly not true that the original meaning of the 14th Amendment barred all race-conscious efforts by government, right? The authors of the 14th Amendment, Justice Ketanji Brown Jackson and Justice Sotomayor emphasized this in their dissenting opinions in June. The authors of the 14th Amendment themselves enacted a number of race-conscious remedial measures designed to provide some benefits for the recently freed slaves, right? And so it does not seem to be the case that the original meaning of the 14th Amendment forever bars all governmental consideration of race. So I'll stop there. Thanks.
Thank you very much for that context. Next, let's turn to Professor Shi. Could you provide us with some information on the empirical evidence underlying the arguments for both sides' arguments in this landmark decision?
Thank you, everybody, for the opportunity to contribute to this panel, for being here, and I appreciate Tom giving an overview of this case. So I'm going to delve a little bit into the particulars, the specific empirical evidence. I'm trained as an applied economist, so I think it's fitting that I'm providing a bit more context about the evidence submitted by two economists, expert witnesses on both sides, and what they had to say about this case. So these two economists were basically tasked with answering what I think are relatively narrow questions, sort of what is the role of race in, let's say, Harvard's admissions process? That's number one. And then another question that they dealt with is, are Asian American applicants, right? Is there discrimination against Asian American applicants in the admissions process? And so first up, you have Peter Arcidiacono, who was hired by the plaintiff side, Students for Fair Admissions. He's a professor from Duke University, and he looked at the underlying data. By the way, both sides had access to the same underlying data, but came to very disparate conclusions, not surprisingly. So Arcidiacono found that Asian Americans, for example, are discriminated against. What's interesting about the Harvard's admissions process is that the admissions committee actually assigns subcomponent scores to 4 facets of applicant files. So they look at the academics, they look at extracurriculars, athletics, and then finally something that's called a personal rating, which is a little bit nebulous. And so his contention was, Asian Americans do better on the sort of academic measures, but are discriminated against in particular when it comes to this personal rating variable. And so on the other side, you have David Card, an economist from UC Berkeley, who looked at the same data set and said, there is no discrimination against Asian Americans. In fact, the conclusions arrived at by the plaintiff side are there's some major shortcomings, right, in their analyses, and that some of the analyses, in fact, were nonsensical. This is not a word that you usually hear academics lobbying at each other in a public sphere, but it got a little heated. And so how is it that people looking at the same data set are coming to such different conclusions? And so there are a couple of points of departure. One is that they're using somewhat different samples. For example, the plaintiff side excludes legacy students and then certain preferred students from the application pool. But then I think a more critical set of difference is really around modeling decisions. And so the plaintiff side, Peter Arcidiacono, chose not to include, for example, these personal ratings in his models. And part of the reasoning is he believes that these ratings themselves embed discrimination, right? And so Harvard, for example, has a long history of perhaps using these types of personality-related ratings to downgrade, for example, probably the most well-known is kind of Jewish applicants based on their lack of character or leadership skills historically, to exclude certain groups of people. And so that there was a decision made to exclude it. And the David Card set of analyses, he says, well, look, Harvard has so many superstar students applying, right? They look just stellar on the academic side. So they have to really resort to a very multidimensional view of the applicant. And so it is imperative that we really need to consider some of these other dimensions. So including things like, extracurriculars and sort of personal ratings, et cetera, et cetera. So, we're not going to be able to settle this question. And you could actually argue that there are modeling decisions that are sensible on both sides. But what I will highlight here is, I think the volume of statistical analysis, there's thousands of pages, right? I think it has something like a veneer of objectivity over a process that is deeply value laden, right? So kind of the assumptions you make about what goes into these models are very much value laden. And I think it falls really far short of answering some of the larger questions, even raising these larger issues, including, what should be the role of selective institutions, right, in a society with a long history of discrimination and exclusion against some of these groups? Like, what should these institutions be doing? And how do we think about, right, the benefits that accrue to certain groups? There's a large volume, for example, of empirical evidence that show that certain students really benefit from attending these schools. And so really think of the statistical analyses here as sort of a teeing off point, but really to kind of broach this broader discussion, which hopefully we'll have later this hour around some of these larger and even normative issues.
Thank you very much for giving us an overview of the empirical arguments behind this case. Next, let's go to Professor Lutz. So you actually have some research using national data sets that examine the impact of affirmative action on student applications to, enrollment in, and completion from selective colleges and universities. I was hoping you'd be able to share some of the key findings from your research with us today.
Sure. So for the past several years, I've been working with my co-authors, Pamela Bennett and Rebecca Wang, on a series of projects that examine the impact of affirmative action policy on student outcomes. So in our research, as you said, we use nationally representative data to examine the effects of affirmative action policy on application, enrollment, and completion at selective colleges and universities. And today I'm going to talk about enrollment and completion. So from the mid-1990s into the 2000s, several states banned affirmative action in higher education. So one of the things that we have examined is what happens enrollment-wise to Black and Latino students in those states where affirmative action is banned. Do they go to other states? Do they shift from public to private institutions? Do they increasingly go to in-state non-selective institutions? And what we find is that Black and Latino students who live in states that ban affirmative action are significantly more likely to go to a non-selective college relative to an in-state public selective college. So the odds of attending a non-selective college instead of an in-state public selective college are almost 3 times higher in the states that had bans than the states that did not have bans. So we refer to this phenomenon as talent loss, because going to a selective college or university offers benefits to students, such as greater academic rigor, increased likelihood of graduation, the pursuit of careers that require post-secondary education, and higher wages. So in these states, the students themselves experience talent loss in terms of their own educational and career trajectories. But also society experiences talent loss because these students could have had an experience in a selective college and they aren't necessarily showing up in the career and leadership positions that they might have had they gone to a selective college. Now, we also examined graduation from selective colleges by race. And this is where we saw a really positive story for Black and Latino students in selective colleges. If we look at students who were high school seniors in 2004 and went on to attend selective colleges, we see a real success story in terms of affirmative action. On average, 88% of Black and Latino students who started at selective institutions graduated, compared to 85% of white students, a difference of only 3 percentage points that is not statistically significant. And these are the raw differences. But if we compare Black and Latino students with similar background characteristics and educational experiences compared to their white counterparts, Black and Latino students are significantly more likely to graduate from a selective college than their white peers. So this is a success story of affirmative action that we don't hear about enough. So what does this mean in terms of what will now be a nationwide ban on affirmative action? I think that the concept of talent loss is something that will characterize the experiences of minority students in higher education. Our research suggests that despite the ability of students to succeed in selective colleges, many Black and Latino students won't have the opportunity to prove their academic skills in selective colleges. The evidence from our research on states that ban affirmative action suggests that with a nationwide ban on affirmative action, more Black and Latino students will shift to non-selective colleges, where they may not have the same educational opportunities that they would have at selective institutions. So that's my research.
Great. Thank you so much for sharing with us. Let's see. So last but certainly not least, let's hear from Professor Drake. So one thing that really makes the discussion around affirmative action challenging is that there is a lot of misinformation about this topic. Could you provide some information on debunking common fallacies about affirmative action, as well as what sociological evidence says about the use of affirmative action in college admissions?
Absolutely. Thank you, Maria. Thank you, Tom, Ying, and Amy, and all of you for being here. So I want to just start briefly by talking about the impact that affirmative action has had on my own family. My parents were born in the early 50s, prior to the Supreme Court case Brown versus the Board of Education, which ruled that purposefully racially segregated schools, that process, that policy was unconstitutional. And so my parents both went to selective colleges in part because of affirmative action policy, because of that civil rights movement and that policy, which absolutely paved the way for me to do the same. And so this is an issue that I care about and have thought a lot about personally and professionally. I grew up in California, in San Francisco. California has a long history of dealing with affirmative action, from the Bakke case in 1978 to Proposition 209 in 1996. I remember walking down the street with my dad in 1996. He was actually a University of California employee at the time, and I was asking him about affirmative action because, it was something that I'd heard him talking about on the phone, or I'd seen it in the news at the kitchen table or something like that. And we were walking down the street and he said, okay, we're going to race to the end of the block. And he said, on your mark, get set. And then he started running before saying go. And so he starts going, he gets a few steps ahead of me. I'm sprinting to try to catch him. I was catching him, but I ran out of sidewalk and we got to the end of the block before I could catch him. And I said, okay, that wasn't fair. You started before I did. And he said, so that's sort of how life is. There are people who have sort of advantages from birth, gives them a head start. And so affirmative action is trying to level that playing field to make sure that everybody has a fair chance to, to sort of compete in this sort of race of life. And so that was my introduction to this policy, kind of growing up in an environment in which a lot of these things were happening. I think it's really important that we remember that racial inequality persists and widens without specific social policy to address it. And sociological theory can help us understand why. For example, there's this theory, a relatively new theory of racialized organizations, put forth by Victor Ray, who's a professor of sociology at Iowa. And one of the tenets of this theory is that whiteness is a credential, right? So being white in American society affords people certain privileges that are not available to people of color, and we certainly see this in education. Sociologist Elijah Anderson, in his new book Black and White Space, reminds us that Black and brown people often face what he terms a deficit of credibility in public life, whereas whites tend to experience a certain amount of moral authority. The late great sociologist Diva Pedra's research provided irrefutable evidence along these lines, as she showed that white men with felony convictions were more likely to receive job offers than Black men with no criminal record at all. And so affirmative action is civil rights policy tailored to a society in which conscious and unconscious racial bias continues to proliferate. It's tailored to a society in which racism often takes on a subtle, colorblind, more laissez-faire quality. Some who argue against affirmative action believe that there is a negative relationship between racial diversity and institutional excellence, such that as diversity increases, excellence decreases. And so there becomes this calculation of how much excellence are we willing to sacrifice in the name of diversity. But this sort of supposed negative relationship between diversity and excellence is actually a fallacy, a myth. The truth is that diversity promotes excellence. And so University of California, Irvine, where I was a graduate student, provides an example of this. While I was a graduate student, UC Irvine became a Hispanic serving institution, which means that its percentage of students identifying as Latino or Hispanic, I think, exceeded 25%. I think now it's up over 30%. And as those numbers increased and the racial and ethnic diversity of the campus increased, its ranking also increased. And now UCI is always among the top public universities, top 10 public universities in the country. So there's overwhelming evidence that affirmative action policy is good for universities, communities of color, and society. And so the backlash to affirmative action, as I see it, is sort of part of its kind of evidence of its effectiveness. And the backlash that's kind of which this latest Supreme Court decision is a part is about anti-diversity, full stop. So there are conservative activist groups and lawmakers determined to enforce this ruling and to make sure that new admissions criteria are not being used as a proxy for race. And the goal is unmistakably to reduce the percentage of Black and brown students in higher education. And so just to wrap up, I think it's important to kind of understand why that is. And again, we can look to sociology for some answers. And so sociologist Herbert Bloomer in 1958 wrote an article called Race Prejudice as a Sense of Group Position. And one of Bloomer's arguments is that dominant racial groups often feel a proprietary claim to society's coveted, valuable, and limited resources, and higher education is one of those resources. Therefore, any policy such as affirmative action that boosts opportunities for underrepresented minorities and benefits and their access to a coveted resource such as higher education is unfair and has to end. Another way to think about this is if you're used to having advantages in something, so much so that you take it for granted and it just seems natural, then things can feel deeply unfair when the playing field is leveled and others have the same opportunities as you do. And I think that's part of why affirmative action is so controversial. So I'll just close by saying that affirmative action has never been, as some people believe, about giving post-secondary education slots to students of color who are less deserving than their white counterparts. Instead, it's been about making sure that talented, hardworking, deserving students of color have an opportunity to see how far that talent and hard work can take them. It's about identifying and uplifting capable students who have historically been discounted and overlooked. And so I'm optimistic that colleges and universities will find ways to abide by this horrendous Supreme Court ruling while maintaining the racial and ethnic diversity on their campuses.
Thank you, Sean, and thank you to all of the panelists for these opening remarks. Next, we're going to move on to the Q&A portion of the panel. So I'm going to start us off with a question, and then we are also going to open up the discussion to audience questions. So please go ahead and send any questions you have to me in the chat box, and I will go ahead and get to as many as we can in the remainder of the hour. So to start us off in terms of Q&A, the question that we have is, how might we think about this decision within the broader context of recent changes to civil rights in the US? And I'll turn it over to the panelists.
I guess I'll just jump in here. And so Tom had mentioned that this case was brought forth by Ed Blum. He's a conservative activist that was behind a lot of these cases involving higher education affirmative action. Ed Blum is also pivotal in another civil rights related case that happened recently, which is Shelby County v. Holder, better known as the case that gutted a key provision of the 1965 Voting Rights Act. This is something that I actually have a pretty active research program on. So I just wanted to talk a little bit more about that case and its implications. And so basically this case invalidated the key provision of the Voting Rights Act, and this happened in 2013, that basically provided additional federal oversight for electoral access, right, among underrepresented groups in particular. And so John Roberts, writing for the majority, right, described kind of famously that this Voting Rights Act is really based on 40-year-old facts, and that his contention was that these facts are outdated. Ruth Bader Ginsburg, in her famous rebuttal, had said that removing this form of federal oversight is akin to taking away your umbrella when it's raining because you're not getting wet, right? And so clearly a difference of opinion there, and really forcefully argued. And so, this case basically assumes it passed. You see a wave of action among local jurisdictions and among states to, for example, institute strict voter ID laws and other ways, of effectively restricting access to the vote. And so we actually, me and several collaborators look at the empirical kind of consequences of this for Black and Latino voters. And we find that this particular removal of the Voting Rights Act, the gutting of the Voting Rights Act, had negative consequences for particularly Black voters' access to the vote. And the evidence is a little bit more ambiguous for Hispanic voters, but similar conclusions. And that this finding might not surprise many people involved in this panel or in the audience, but somewhat surprisingly to us, we are the only kind of research team, as far as we know, that document a negative effect. There's a couple of other research teams that find a positive effect, in part because they argue that people are so angry about this decision, right? So they're more aware of the sort of widespread efforts to disenfranchise the vote, and so maybe they're more motivated to turn out. But we actually find the opposite. We find a negative vote or effect. And so this is really this decision. I think I just want to cast it as part of this broader effort to kind of erode various kind of civil rights legislation and sort of efforts, and certainly more empirical evidence is needed on to document their consequences.
I'll just jump in with one. I really appreciate those comments from Ying, and I'll just jump in with one quick additional point. Yeah, the voting rights connection is super interesting, and in addition, in addition to the lawyers involved in bringing these cases, if you look at the judges as well, right? I mean, so John Roberts worked in the Reagan Justice Department, and he would, when the Voting Rights Act came up for renewal in the 80s, Roberts was the point person urging Congress not to broadly renew it. And the Supreme Court had scaled it back a little bit, and Congress was trying to expand it again. And Roberts, back in the 80s, was arguing against those expansive protections for voting rights. And now, as Chief Justice of the United States, right, he's in a position, obviously, to write those views into law. And so we see a lot of examples of this. I mentioned abortion, Ying mentioned voting rights. We can look at lots of different contemporary rights conflicts, and the kind of consistent through line is that long-standing conservative demands for retrenchment in our understanding of constitutional rights now have a really powerful and vocal and robust and aggressive majority on the Supreme Court in their corner. And so I don't think we've seen the last of it on any of these issues, right? That the judges, with support from the lawyers, are continuing to push U.S. constitutional law in a conservative direction. The one last thing I would say about that is this is not the first time in U.S. history or in the court's history that this has happened, right? There's a kind of ever-present sort of cycle of the court being pushed and pulled by political movements over time, right? And it has not previously been the case that the court's word is ever really final over any medium to lengthy period of time, right? So for folks who are concerned about any of these decisions coming from the Supreme Court, I just encourage folks to stay engaged, right? To focus on what your elected representatives are saying about these issues, what they're proposing to do in response to the court's decisions, and the court's decisions are part of an ongoing dialogue amongst multiple lawmaking institutions, and the court's word does not have to be final.
All right, thank you, panelists, for weighing in on that. Next, we have a question from the audience. And the question is, what will universities do to prevent an erosion of trust in an educational system that will have fewer Black and Brown students and instructors because affirmative action has been banned? Black and Brown people will likely see the system as completely rigged against them, so why bother applying?
So in my research, we looked to see what affirmative action bans did in terms of applications. And what we found is that in states where there were affirmative action bans, there wasn't really a difference in terms of Black and Latino applications to selective college. But we did find that white and Asian students were more likely to apply to a public selective college in those states. So there may be some impact on applications as a result of this decision. We don't know if, what happened in the states will happen at a nationwide level, but that's what we found. I think that there is something important that colleges and universities need to pay attention to in this context in terms of making an atmosphere where underrepresented minority students feel comfortable in the university, because that is very important to feel like they belong in that space.
I'll just add on to Amy's comment, and this is not my research, but one of the recent papers that came out in economics about the affirmative action bans. So they were looking in California, and then basically what they found was, ever since the 1998 ban, the number of Black and brown applicants, right, decreased significantly. And this is, that the body of empirical evidence, I think, suggests that this is a margin that, people should watch very, very closely. And, one may expect that we would have a pretty significant drop potentially from these applicants. And, it takes so many years to build up trust, right, with these communities and try to say, you should apply to these schools. And I think, this decision and others really kind of erode that trust. I certainly acknowledge that. There already have been, I'll mention pretty significant changes to a lot of these schools' application processes. So like, let's take Harvard as an example. I'm pretty sure they used to have like an optional long form essay. And now, given this decision, I think John Roberts' majority opinion had left open the possibility that students can use race only insofar as it kind of shaped their life experiences. So now Harvard's admissions process has 5 short form mandatory short response questions, a couple of which kind of get directly at this issue of like, how have your life experiences or extracurricular activities shaped who you are as an individual? Just trying to provide space for some of these students to describe how, for example, race and ethnicity might have influenced their lived experiences. Now, with that said, my cynical prediction is that there's going to be like a huge cottage industry growing out of this of like, college application consultants, right, charging hefty fees to kind of navigate you through this process, and access to those individuals are going to be disparate, right, depending on what your kind of family wealth and socioeconomic standing is. So there's certainly a lot of scope for the perpetuation of inequality here.
Yeah, just to piggyback on that. Yeah, I think looking to California provides some evidence of what will happen. So kind of in wake of the Proposition 209 decision in 1996, it had a devastating impact on the percentage, for example, of Black students in the UC system at the undergraduate level. For example, I think UC Berkeley went from 9 or 10% Black undergraduate students down to maybe 2%. And so I think that, more than affecting the numbers in terms of admission, in terms of applications, it affected a lot of the numbers in terms of admissions. And it took a while for the UC system to adapt to that ruling. And one of the things that they did, as Ying just alluded to, is really focus on those essay questions, and so students of color can write about their experiences in unique ways that may be attractive to admissions to admissions committees. And so really trying to develop questions that anybody can answer in any way that they see fit, that gives space to talk about issues, issues of race, issues of inequality that somebody has dealt with or overcome, those challenges in their life, or things they want to do in the future in kind of a racial justice capacity, that might be attractive to admissions committees. And then I think also, universities, I think in response to this, are going to change some of their admissions criteria. We've already seen the SAT. There's been a lot of research about racial bias in terms of the SAT, how a lot of times the test questions, word problems are sort of are biased in certain ways that kind of reproduce the status quo in terms of who's really doing very well. Also, if someone's family has the resources to pay thousands of dollars for test prep, then that can give that person an unfair advantage, or at least an advantage that others don't have. Even if they have every right to use their resources that way, not everybody has those opportunities. And so we've seen a lot of universities pull back from standardized testing, making SAT optional or scrubbing it altogether from admissions. So I think we're going to continue to see more of that. And then I think universities will focus a lot more on recruitment and retention of underrepresented minority students. So encouraging those students to apply, and then making sure, as Amy said, that they have a positive experience on campus as well.
Great, thank you very much. So next I'm going to summarize together a few questions from the audience that all kind of address this theme of what I like to think of as the flip side of affirmative action. So policies that, policies that kind of privilege students who are already privileged in the admissions process. So thinking about things like legacy admissions, or thinking about, student athlete admissions, especially with respect to what types of sports some of these more selective institutions tend to have compared to other institutions. So in my own preparation for the seminar, I did go and look up, what varsity sports does Harvard offer compared to what varsity sports does the University of Massachusetts at Amherst offers. And there's a lot of overlap, right? There's basketball, there's soccer, there's tennis, things like that. But then in addition, right, Harvard has sports like golf, fencing, sailing, skiing, squash, right? And so the big picture question here is, how can institutions of higher education seek to address these tangible systems of privilege benefiting historically dominant groups? And also, what role do these policies have in college admissions moving forward?
I think that one of the things that we need to realize is that in the absence of affirmative action, and even in the presence of affirmative action, white students have advantages in getting into selective colleges. So you mentioned legacies, donors, the athletics. Athletics is something that I think a lot of people don't think about in terms of an advantage in terms of getting into a selective college. But there's a new book out by Natasha Weriku who talks about how white families are kind of preparing for college by getting their kids into athletics. And that's a strategy for getting into a selective college now. So I think that's something that the colleges will have to address, and I'm not exactly sure how they plan to address it. But I think that that's an important thing to address in terms of admissions, these advantages that white students have over students of color in terms of admissions.
Yeah, and I think just to dovetail with that a bit, right, that's why when sort of repeal or roll back civil rights policies, then you see racial inequality widen, because there are advantages, right? There is this racial stratification in our society which is the reason why we need these policies in the first place. So taking the policies away does not level the playing field. In fact, it sort of widens those gaps. And so that's sort of that's my that's sort of my worry, is that we're going to see a widening of that inequality. I have one word that I like to say about legacy admissions, right? So because of policies like affirmative action, other civil rights policies, we've see a lot more Black and brown students going to college and graduating. I spoke about my parents' generation kind of coming out of the civil rights movement, for example. We've seen a lot more Black Americans able to reach the middle class, for example. And so legacy admissions also affect students of color as well, right? Not every legacy admit is a white student. And so I think one issue with legacy admissions, I think it's absolutely right to focus on that. But some legacy admits would be students of color. And again, as a legacy student, it doesn't mean that you're going to be admitted to the school, just like affirmative action doesn't guarantee anybody admission anywhere. But it's something that universities can use as part of evaluating an applicant's file. And so I think it's important to realize that not everybody going to a selective college is white. Not everybody going to college is white. It's much different than it was, many decades ago. many of these universities have grown far more diverse. And so legacy admissions brings in everybody, including non-white students. And so I think as we think about legacy admissions, it's important to remember that, legacy admissions does not mean just white families and white students. And so I think we have to be careful about how we kind of deal with that policy moving forward.
I would just add one quick additional point too, with regard to how the kind of legacy and other sort of non-academic admissions factors play out in the context of litigation, right? So like, as I mentioned, right, folks have been litigating against race-conscious affirmative action for 50 years. And throughout that time, people have pointed out, like in response, like, wait a minute, we have like universities considering a million different non-academic factors, and the only one that's not going to be allowed is any consideration of applicants' race. That doesn't, just as a policy matter, that doesn't make any sense, right? But the thing about courts as policymakers in the US, right? I mean, courts and judges are clearly political actors, but they operate in their own distinctive ways, right? And so judges who are influenced by their own conceptions about affirmative action, that's going to shape their interpretations of the Constitution, but within limits, right? And so like they can, even if I think this is a misreading of the 14th Amendment, they can read the 14th Amendment as a bar on governmental consideration of race. They can't easily read the 14th Amendment as a bar on governmental consideration of your legacy status, right? It's just the 14th Amendment doesn't really say anything about that, right? And so for opponents of affirmative action, they have an avenue via our current federal judiciary to try to really put some limits on this policy. For opponents of legacy preferences, they don't have that same, like they're gonna have to do something different, right? But the lawsuits have the effect of drawing more attention to these issues and processes, right? Because lawsuits get media coverage, right? And one of the things I've written about in some of my research on affirmative action and also on some other issues is that the downstream policy implications of controversial judicial decisions are sometimes somewhat unpredictable. Right? Just because the court says X doesn't mean like everybody does X the next day, right? Sometimes there's non-compliance with court decisions. And sometimes there's what I've described as like kind of policy vacuums, right? Or like a court decision disrupts the existing policy status quo, like Harvard is not allowed to just do it the same way it's been doing it, right? So they have to change something. And then they're like, okay, well, we can't consider race anymore, but oh, maybe we should also tweak these other things. Right. And so no court is ordering any university to get rid of legacy admissions. But I think it highly likely in this current moment that, I mean, some of the universities have already done it. And I think more are gonna move in that direction because the litigation campaign has sort of disrupted the policy status quo. Universities committed to recruiting diverse student bodies that are now not allowed to consider race. Many of them are now also going to consider some of their other non-academic factors. And so I think that's I don't know, if you think that legacy admissions practices are unfair, that's a sort of silver lining maybe of hasn't played out in full yet, but it could be a silver lining of the recent decisions.
Well, related to, oh, sorry, go ahead, Ying.
Yeah, I was just gonna just like piggyback on that really quickly and say that like there is, like everybody's kind of alluded to, an increasing volume of attention paid to legacy, right? Admits, and there's been a lot of like recent empirical research. Raj Shetty and others have looked at admissions among elite colleges and found all of these sort of advantages being conferred for select applicants. And then if you look at the empirical evidence for this Harvard case, the sort of this group of students, right, on these dean's lists or sort of children of alumni, they comprise only 5% of the applicant pool, but they comprise 30% of the list of admitted students. So think about that. I mean, if you look at the numbers, and I don't remember the exact values, we're talking many times the likelihood of being admitted here. So the advantage conferred is really enormous. And so it really draws a lot of, attention towards these issues. And so I'm kind of interested to see how it bears out.
Related a little to what Thomas and Ying were talking about, the next question is, What are the alternatives to affirmative action to creating diverse cohorts in colleges and universities, and how successful will they be?
So there are several alternatives to affirmative action. I don't believe that any of them are as successful as affirmative action in terms of creating diversity, but you have top percentage plans, such as the one used in Texas. So if you're in a certain top percentage of your graduating class, you have automatic admission to the flagship. This type of program is effective in terms of diversity only to the extent that schools are extremely segregated. And I was just reading recently that the level of segregation in schools, I mean, I don't think we should be like promoting a policy based on more segregation of high schools. But the level of segregation of high schools is not enough to truly make this policy one that promotes diversity. Another popular option is using class instead of race. Most analysts of this project feel that this will not increase diversity to the extent that affirmative action does. There is one sociologist by the name of Sigal Alan who says that this can be successful in terms of diversity if you get rid of all other preferences, including legacies, children of donor, and athletes. But that's, I think, a tough sell for colleges, especially the athletics. Targeted recruiting, like Sean said, is something that colleges should be doing, and many are already doing, trying to promote applications among students from different schools, going SAT optional. Another thing that the sociologist Thomas Espenshade has really focused on, and this is not something that colleges can do, but equalizing the K through 12 system would make affirmative action less necessary in colleges. So right now, white students have an enormous advantage in the K through 12 system. And so they're not coming into college on an equal footing with students of color in terms of the application process.
I also want to add, Amy, I agree with you in terms of my read of the literature on these other policies that have tried to target racial diversity, things like top percent plans, things like targeting class. They don't reproduce racial diversity the way targeting racial diversity does. And one other thing that I'd like to add is there's also been research showing that these policies, they kind of, incentivize people to game the system, right? So there's been research showing, looking at the top 10% policy in Texas, which is a policy that admits all students who graduated in the top 10% of their class. There's actually research showing that, families are responding to these policies by moving districts, by moving to adjacent districts where their children have a better chance of getting in, right? And when you think about what types of families or who has the resources, right, to be able to just up and move their homes, right? That's certainly not disadvantaged groups.
Yeah, that's a good point.
I think quickly, just to go off a couple of those points, I think class-based affirmative action is not wouldn't necessarily work well at all. Most lower income applicants in the United States are white anyway, so you could have a class-based affirmative action policy and it could lead to far less racial or ethnic diversity on campuses. So I think that it's a good idea. It sounds good, but I don't think it will improve diversity. I also think, just to go back to legacy admissions briefly, I'm a bit skeptical that doing away with legacy admissions will actually do anything to improve diversity on campuses. It may be it may seem like a fair, kind of the right thing to do in response to this ruling. Sort of like an eye for an eye sort of thing, but I'm not convinced that it will do anything it's not a substitute in any way for affirmative action policies. So I think that it's important, as we're sort of thinking about legacy admissions and what to do with them, not only to think about the legacy admits that may have been students of color and what it might do to those applicants, but also the fact that even doing away with legacy admits for, just period, won't necessarily improve improve diversity at all. So I think that those are just 2 points that I kind of wanted to make. And then yeah, again, to repeat a little bit of what I said before, I think really focusing on recruitment and retention of students of color. You know, I've read, you know, recently, you know, some putting forth the idea of focusing on recruiting, you know, certain neighborhoods, you know, certain, you know, targeting certain neighborhoods, right? You're not targeting a racial or ethnic group, you're targeting a neighborhood. So I think that there can be some targeted recruitment. You know, recruitment, again, it's not admissions, it's just inviting people to apply. And I think that may be a way to make sure that these applicant pools, you know, stay diverse, increase in their diversity, and then universities will find, you know, ways to evaluate applicants, you know, in even more holistic ways. And you know, I'm optimistic that, you know, there's a lot of smart people at these universities, these colleges, and that I'm optimistic that over the next couple of years, as the adjustments are made, that that this ruling actually won't move the needle that much in terms of diversity on campuses.
All right, I think we maybe have time for one last question. And this last question, it's a few people had this question about, you know, what specifically does it mean to ban affirmative action? So, you know, what about what Harvard and UNC were doing made it so that this was technically affirmative action? Or how, you know, how can colleges not include race as a decision point? What if a student talks about, let's say in their essay, how they overcame racial adversity growing up as a result of them being part of a disadvantaged group? You know, what can and can't colleges do with this type of information?
I mean, I can answer part of that question, right, from the court's perspective, right? And so several folks, both questioners and panelists, have mentioned the issue about admissions essays. And there was a lot of focus on this last year because of a line of questioning from Justice Ketanji Brown Jackson during the oral arguments, where she laid out really a quite compelling sort of scenario where she described two hypothetical applicants to UNC Chapel Hill. And one is a multi-generation, like, white legacy who writes in his essay about all his, you know, fathers and grandfathers and great-grandfathers who attended UNC and how he wants to follow in that tradition. And the other is a Black student whose family predecessors were prohibited by law from attending UNC, right? And they could write about that story. And like, what would it even mean to say that university, like, admissions officers, like, couldn't read those essays and like kind of take those different stories into account? And UNC Chapel Hill currently has legacy preferences, so they could clearly weight that one as a plus, but they wouldn't be allowed to weight the Black applicant story. And that line of questioning at oral arguments drew a lot of attention at the time. I think it is part of the reason why Chief Justice Roberts' opinion has some language in there that says, you know, we're not saying that applicants can't write about their race and universities can't consider how that has actually affected their life experiences. But what that's actually going to mean in practice, I think it's just, we don't know yet, right? Because there's further lawsuits already filed. The opponents of affirmative action are very much convinced that universities for decades already and continuing are determined to disobey the law, right? I mean, they are very much convinced that the limits that were already in place, universities have been flouting because they're too committed to racial diversity. That's what they think is the case. So they're going to keep filing lawsuits to trying to keep tightening those screws. And so the thing that we don't know is whether federal judges are going to go further than they've gone in these recent cases at kind of imposing even more, right? Like, if a plan that targets applicants from certain zip codes, which is completely race neutral on its face, but if it's adopted in an effort to promote a diverse student body, Ed Blum clearly thinks that's unconstitutional too, and we don't know how the court is going to respond to those further questions.
It's not like places like Harvard and UNC Chapel Hill are just, you know, teeming with Black and Latino students. You know, they're not like, so I think part of it is just simply a backlash to civil rights progress. And there's a lot of people that don't like it. and they want things to be how they were 50 years ago. And they feel that certain people don't deserve those opportunities. And so I think a lot of it is about that. The policy has been very effective. Universities have, are fundraising at record levels. All these things are happening. So it's, it's again, it's not this, it's not an either or. It's not, we can have diversity or we can have excellence. In fact, there's so much evidence that the two are co-modifiers. You can have both at the same time. Both can grow at the same time. Universities love to tout that their latest freshman class is the most diverse in history and the most academically prepared and impressive in history. So, these are things that can go together. And so I think a lot of the backlash is really about who do people believe deserves to be at a place like UNC Chapel Hill or Harvard or a University of California school. I think it's also important to remember that the vast majority of colleges and universities are not highly selective. They admit almost everybody who applies. So we're really only talking about a small percentage, right? But these are the schools that people get very worked up over because of their prestige and their ranking and the sort of credential that it means to be there. So I think that at its core, that is what this argument is about, because, as you were saying, Tom, and as others have said, there are other things that universities do in admissions. And you can say, well, if you're not going to consider race, then how can you consider this? Or how are you considering that? And I think the reason is because of a certain amount of people feeling like these schools are there's like too much change, too much progress, too much diversity on campus, and so we have to roll those things back, right? Back to the umbrella analogy. It's like that umbrella is keeping us a little bit too dry, so we don't need it anymore. Maybe we can be a little bit wet after all. And so I think that's really what it's about. And just as we've seen throughout American history, it's just we take steps forward, we take steps backward, and I think we're just going to have to stay kind of vigilant about this and continue to try to push things forward despite this political and judicial climate that we're in.
Thank you. Well, we are out of time now. So, I wish we had gotten a chance to get to all the questions. There were many good ones. Let's see. But I do want to wrap up by thanking everyone in the audience for engaging with us today. I also want to thank our panelists for joining and providing their expertise on this topic. A recording of this event will be made available on the CPR website in the coming weeks. Thank you again, everyone, and we hope to see you again at future What's at Stake events.